We don't have only the jury instructions to discuss today, but also information about the next trial. Because if you're just now following along, there is another Lori Vallow trial coming up. It gets confirmed right at the start that Lori says, as of this morning, she still does not plan to put on any evidence and doesn't plan on that changing. They don't read the full jury instructions, by the way, during this hearing, so I can't give you those. We'll get to hear them on Monday, where I'll probably go and shorten them down. There was some discussion about the instruction that neither side is required to call basically everyone mentioned in evidence, so it's an instruction that's basically like, look, because I mentioned Tylee doesn't mean someone has to call her, right? The judge seemed to consider it standard, but the state didn't agree and suggested it could be burden shifting since the defense doesn't have to have any witnesses ever. Lori agrees, so it's struck. It's not a big deal. And the instruction that the indictment is not evidence, comments are not evidence, no issue with the credibility of witnesses instruction, nothing about expert witnesses instruction. They took out some things because Lori isn't testifying, and I think most importantly, it was the instruction about the defendant's prior conviction. Defendant's prior conviction is removed. That instruction being removed means that we are basically sealing it unless Lori changes it. The jury will not know what happened to Tylee and JJ. That's not going to be told to them. Unless Lori changes her mind on Monday, that's done. Lori wanted something added about voluntariness of defendant's statements. No objection. The jury is not to consider the penalty this crime could give if convicted. The state wants a new version of burden of proof that just explains the burden of proof for a criminal case instead of other levels. Lori agrees. Judge thought it was okay, but that happens a lot. The judge is like, well, I think it's fine, and both sides are like, nope. Lori doesn't have to produce evidence. It's left to the defendant. Is changed. Basically, how do I want to word this? It was a little confusing because we're only hearing parts of it. There is an instruction that's about the defendant doesn't have to produce evidence, but it also talks about a jury representation, and because she's representing herself, anything about her representation is removed, basically. So she gets to make the decision. They changed using first-degree murder with a number to first in letters. Whatever. And I think at certain points they changed the word defendant to he or she. I don't know. That part was kind of skipped over. We'd have to actually see it or hear it said. They added a definition of accomplices. Lori wants to see that herself before approving it, but basically they just want to explain to the jury what an accomplice is. State wants to change an instruction to be just deadly physical force because that's clear to the jury about something. Remove some unnecessary words, and Lori agreed to that. Judge agreed to that. Lori wants an instruction about crime prevention to be added. And the judge had my response and goes, what crime was prevented? And Lori says the assault on myself, my daughter, and my brother. Defense of third party, defense of premises, and crime prevention. Lori wants it added for defense of deadly force. Judge thinks he has to add it. The state says premises isn't appropriate since Charles was originally invited into the home. Judge takes a closer look when it comes to it being asked to leave. He would hate to cause a reversal on that. Basically, it says, like, if you're invited in, you're told to leave. You don't, it can still be invasion of premises for this defense. The state brings up a very important point. Charles Vallow was paying for the premises, and that's admitted with evidence. And Lori, and I mean very snappily, the Lori, I don't even know how you describe it. Her attitude, you know what I'm saying if you've watched any of the trial. Her little attitude says, admitted evidence is also that he flew into town and came over to that house not living there at the time. And the judge responds real simply. He's on the lease. The state says it refers to criminal trespass, and you can't be criminally trespassed off your own property. The judge says yes to third person defense, but not the premises. Lori then wants to add defense of residential structure. Lori's attempt doesn't go in because that's about home invasions, and there's no indication that he forcefully entered the home. State agrees that crime prevention can be added, but Lori would have to tell the jury what crime it is. She'd have to, if it's prevention, there has to be a crime. So the crime he's committing would have to be explained for that to be possible. Basically, what we're doing here is we're setting up the instructions, which is also going to kind of set up what the closing arguments are going to be, right? Because they have to check these boxes. You saw it before if you followed a trial, especially the Sarah Boone trial. The state kind of went down through the instructions. Here's what we're doing. Here's why we're right. Lori missed something she wanted to add. Oh, the state needs to review what Lori added before officially approving it. Lori missed something she wanted to add earlier. She wants a change about ignorance not being justification. And the judge asked what change. And at this point, I actually had to go back. So I'm like, what is she saying? Is she saying she's ignorant? Because it's like ignorant of, I was like really confused. And Lori goes back and talks to her team and then says, 1 shot, 2 shot, being attacked, not being attacked. Those are things the state might say. And the judge says you can deny those things, but that isn't what this is about. This is about mistaken fact to get out of criminal liability. Maybe you shot a burglar breaking in and it was actually your spouse getting into the house because they locked themselves out. Something like that was the premise the judge gave, and that doesn't come in, and Lori is all right with that. Lori confirms again that she expects to just say defense rests when the jury is in on Monday. State asks, in that case, for all the officers that are under her subpoena to be released, and that's approved. And then the judge just says, well, we can release all your witnesses then, and that gets approved. So if Lori on Monday decides she wants to put on a defense, all of her witnesses that, any of them that actually got the subpoena and everything, they would be released already. So I don't know how that would work. So I think it puts Lori in a position where she's now more forced before to just say defense rests, because all she could really do is testify for herself. At least that's my understanding. Instructions on Monday, then lunch, and then closings start after lunch. Basically, they don't want to break up closings between lunch. It makes sense. Sucks for me, personally. I'll get to that, I think, at the end if I remember. Now we move on to Lori's second case. Yes, that's being talked about. Trial date was set for May 30th at 10 a.m. their time. Final trial management conference, May 14th, 10 a.m. Might move if the victim needs it. The victim's not there to agree, right? And they can be there. Maybe the 29th of May to go over the questionnaire results for the jury. The state thinks the second trial will probably take about as much time as this one. So if you're wondering how long that's going to be, a couple weeks, right? They want to work on possible dates for June now, kind of schedule when the court's going to be. They got to tell the prospective jury that on the questionnaire, and also so they can start getting witnesses and try to pin down, make sure people are free. So the trial this time will actually be Monday through Friday. I don't know why they're doing a difference there, but the judge says, and I love this, he has to go dark. The 16th through the 20th. Listen. He probably didn't think anything of it, right? He didn't probably think anything of it, but I did. You probably did. Lori most definitely did. State probably noticed it too. Going dark, being dark. Oh boy. The state would rather screen the jury through June 3rd to be safe. The judge was kind of disagreeing with this. He's like, we'll confirm it on the 14th of May. There were some disagreements about how this trial is going to be set up. The state kind of wanted to delay a little longer to be more careful with the jury. I appreciate that. Remember, we are at a jury that lost multiple people. They had people on their phones during actual testimony. We only have 2 alternates left, and honestly, we probably should have restarted with a mistrial with how many issues there have been with the jury at this point. It's been a problem. So I understand the state. But the judge is worried that if they start when the state wants, that this trial is going to bleed into July 4th, and they're going to lose so many prospective jurors because they have somewhere they have to be on that date. Lori objects because they're going to exclude time, and Lori wants her speedy trial. Lori, you would think she can't even get witnesses to approve to come, right? but she wants her speedy trial. She doesn't have enough time to put on her defense, essentially, but she still wants her speedy trial. She wants to be in trial by May 11th. Lori, I have possibly Oblivion coming out Monday. You are already going to possibly screw me playing that game on day one and making content if it comes out that day. And now you're saying you want to restart that quickly? I can make videos on Oblivion forever. You're testing me, Lori. But the judge explains that they simply couldn't do 2 trials at once. The judge is out part of the time. The state needs to get out-of-state witnesses and schedule them coming in. And the delay is of minimal prejudice considering, and I quote, all those sentences you are serving. A little spice at the end there, in my opinion. It's accurate, though. She's not going anywhere. I think she wants to get back to prison. So, no matter what happens Monday, Lori isn't going anywhere till at least this time in June, probably. Minimum. She'll be this time in June, probably later than this time in June, in that jail, where she acts like she's on a mission. If you haven't seen the interview from the jail, you should watch it. Mission, like, from a church. For family tragedies. So, that's kind of the scheduling. Obviously, I'm going to do everything in my power to cover the second trial, too. As I said, I got in a little rant earlier. Yes, I do plan to do a video on the Monday. The way that'll work is I'll probably record the jury instruction segment and Lori setting, like, ending her case. I'll probably do that, cut that as a video. I'll then go and take the afternoon and I'll do closing argument videos. All of this will be combined into one video. After closing arguments are given, everything's done. I will then release that video, render it and release it. So at that point, we have to talk about the final answer, right? Guilty, not guilty, the verdict. Probably will be a separate video because we don't know when that'll happen. I'll try to get a video out about the verdict and initial thoughts and whatever as soon as I can. Lori's reaction in court, things like that I can do. And if you watched my Sarah Boone, I believe a couple days later, I did like a afterthoughts video where, like, the whole trial's in your head and you go back and you think about it. Anything else that might have come out, any statements from the family can be discussed that, have been aired, because people will say things when the trial ends. No matter what, they're going to say things. God forbid. Oh, man. I could just imagine the hurt the family will feel if she gets not guilty. But I don't think that's going to happen. I don't think you think that's going to happen. And then, of course, if the jury gets interviewed or anything like that after the case ends, we can, I can do like follow-ups talking about that a little bit. After that, I mean, there's not much until they're working into the next trial. So I don't know what'll fill the gap in there. It might be mostly me on Oblivion for my other channel, as like a break away from true crime for a bit. Might not be. There's other stuff I might cover in the meantime. Who knows? But I just wanted to give you an idea of where we're at, what happened today. It is actually coming to a close, partly. But remember, there's always another trial.